Good day, everyone. Eric from Helps YouTube Live today, uh, January 29th, 20, 2026. Sorry. I'm coming to you live from Dryates YMCA. And this is YouTube from Helps. Help stands for Help Eliminate Legal Problems for Seniors. Been an attorney now, 46 years? Long time. And the founder of Helps. Helps is a national law firm. What we do is represent seniors and disabled persons who owe debt they can't afford to pay. Our main mission is to stop debt collectors from harassing seniors. We do that under a federal law called the Fair Debt Collection Practices Act. Provides when you're represented by an attorney, debt collectors have to leave you alone. And that's what Helps does. When people find out about us and they enroll, they give us the creditors they owe money to, they don't want to pay, we send out what's called a cease and desist letter, and the debt collectors have to leave you alone. And our second mission is to educate seniors how they can maintain their financial independence. And that's one reason we have these YouTube live sessions, so we can answer questions, and I talk about other people and their problems that might relate to you and might be helpful for you. So thanks for participating. If you have a question or concern, you can always ask me. I'll be glad to answer it. Kat says, Eric, I got a letter from a collection agency for my deceased sister. They put to her estate. What do I write on the envelope to return to them since they know she passed? If there's no estate, then you just write on there, no probate, no assets. If all the assets going to you because your name was on the asset, no, that's all you need to do is just let them know there's no estate. So what counts as an estate? That's a good question. A lot of times I'll read articles on YouTube or something say you have to have a will. Well, I would guess that probably 2/3 or 3/4 of seniors pass away and have no need for a will. I mean, when you're younger, that might be important because you can say who takes care of your kids. But for a lot of seniors of modest or lower income, there really is no estate. Any money they goes to pay for their medical expenses when they pass or for their funeral expenses. And they may have a little bit of furniture, but it's not worth anything. Maybe they have a car, maybe it's not worth a whole lot, or maybe they have someone else's name on it with them, or maybe if it's sold, the money would go to pay for the last medical care or their funeral expenses. So for a lot of reasons, a lot of seniors simply don't have an estate. So an estate is if there's assets that need to be distributed, either used to pay creditors, and then after creditors are paid, then the balance goes to pay heirs. But if you're buying a home, for example, and you had your name on it with your kid's name, then when you pass away, the home automatically goes to the kids. There's no estate, okay? So, or if you're a husband and wife and the husband passes away and everything was owned jointly, then there's no estate for the husband. The property just, his assets just go to the wife because they owned it jointly, okay? So for a lot of reasons, there's a lot of seniors don't have an estate they have to worry about. And if you ever have any questions on this, you can always call and talk to Helps, okay? Okay. So here's someone that contacts us from California. Right now they're current on their debt. They're married. They're not sure if the debt is in her name or both their names. They want to know if they can keep a credit card. And the answer is yeah. One of the questions that we ask people when they talk about Helps, do you have a credit card with a small balance or nothing is owed that you still want to keep? And if the answer is yes, you can keep that card as long as it's not backed by a bank with whom you have another card you're not going to pay. They said they would like to open a new account at a credit union. And do they follow the rules? Yeah, yes, they do. There used to be a problem years ago with credit unions but not so much anymore, not really. Uh, let's see here. Hold on a second here. I'm on my laptop, had to make sure it was plugged in. I think it's plugged in. I hope it's plugged in. But we got a little bit of juice. At least we'll go till we run out. Okay. Um, that might be a while though. So these people contact us. Uh, they both receive Social Security, and the husband has a private pension. Um, and the wife has a job, but her income that she makes less than 217.50 net per week. In other words, she makes small amount of money. It can't be taken even if someone has a judgment against her. And we went over their wage protections, why they didn't need to worry. They're leasing one car and they own another car, and they have some debt with a debt consolidation company and a lawsuit. Um, we talked to a lot of people enrolled in debt management or debt settlement companies, and one thing we'll ask people that are enrolled with a debt settlement or debt management company is when you enrolled with them, did they tell you that your Social Security and your pension was protected? And almost always the answer is no. Um, they withheld the most important piece of information you need to know. If you're struggling with finances and need money for your food and your medicine and your rent and your utilities, your income's protected and no one can take it. And if you, if you weren't told by a debt management company or a debt settlement company that your income was protected, you weren't given complete information. If they would have told you that your income was protected, you didn't need to pay the debt, you wouldn't have enrolled with them and they wouldn't be making money off you. So we talked to a lot of seniors, some of them put into utter poverty, making a payment to a debt management company that they really don't need to make. Okay. So this person contacts us from Florida. Um, and apparently they'd spoken with me about a month ago. They have a savings account with almost 6,000 in there. They're going to close the account and they're going to put the money in a place where it's safe. See, the rule is that twice the amount of your Social Security deposited into a bank account is automatically protected from garnishment, regardless of what monies are in there or where they came from. Okay? So if you got 1,500 in Social Security, 3,000 in your bank account is protected automatically. Now, if you had more than that in there and someone sued and got a judgment and they garnished that bank account, the bank could hold up that money and you'd have to file what's called a challenge to garnishment or claim of exemption to be able to show the court that the money came from an exempt source, and then the court would order it be released. But as long as you keep the balance less than twice the amount of your federal benefit, like your Social Security, then they can't take anything. The bank will protect it completely without you needing to do it, anything. So we sent this person emails about what we do and about garnishment, what happens when a person gets sued, why they don't have to go to court. Um, and it looks like Looks like they enrolled. I didn't have to worry about this anymore. Sorry, I'm on my laptop, so it just doesn't work as good as normally. Person contacts us from Georgia. Um, Husband is 70, the wife is 68. They get 19, he gets 1900 in Social Security. He says, he's aware they can't take my income, but can they come after my assets, my home, my car, etc. Um, and what we told him is, it's not the practice of consumer judgment creditors if they get a judgment to go after your other types of property. Why don't they? Well, almost all states have what are called exemption laws, which exempt a certain amount of equity in different property, like equity in a home, equity in a car, equity in personal possessions. They just don't come after your other assets. Okay. Um, they called back for some more information. Looks like way back in August. And then they received a summons from Synchrony Bank back in August. And we reviewed again what we did and explained why their income was protected. Um, then they called in January, and we called them back, and they were thankful for us calling them back. And we explained that, if you get sued, I mean, you can just, if you don't owe the debt, you can dispute it if you want. But most of our clients aren't interested in doing that, or they owe the debt. You're judgment proof. They can't do anything to you. If your income, Social Security, or a pension, it doesn't matter if they get a judgment. As long as you keep the balance less than twice the amount of your federal benefit, then no one can take anything from you. This person writes in, I appreciate what you do every day for us. I have another question on auto insurance. When I went online to look at lowering my liability to Michigan's lowest limit, they removed my underinsured driver's coverage. I'm not sure why, and I'm not sure if that's a problem. I know someone who was in an accident without that coverage, and they weren't able to get any insurance to purchase a new car. And I'll explain that. Okay. Normally, car insurance, there's different types. There's liability, which the state requires that you carry. And then there's comprehensive, which is like if a tree falls on your car, or something like it gets flooded, pays for your car. That's extra. Don't have to have it under state law. Now, if you're buying a car, the lender's going to require you have comprehensive. And then there's collision, um, um, which means that if you're in an accident and it's your fault, they're going to cover the accident and pay for your car, and a lender is going to require you to have that insurance. But if you want to keep your car insurance low and you got an older car, you may not need liability. You may not need collision or comprehensive, just liability. And what underinsured motorist coverage is let's say you're in an accident with someone and it's the other person's fault. And maybe they only had a minimal amount of insurance, maybe only, some state it could be as low as $10,000. But they damage your car and your car is worth more than that. And so there's not enough insurance to cover you because the other side's at fault, but they only have 10,000 in insurance. Underinsured motorist coverage is you can buy insurance that will protect you and pay you money for damages, either physical harm to you or more money for your car, um, based on the other party not having insurance. Your insurance will cover you as though they were insured. And not, but it costs money to buy that insurance. So if you're a senior and you're on minimal income and you have an older car and money's tight, then probably the only insurance you may need is just liability insurance, which is the insurance that you're required to carry by law. And then you don't need to have the maximum, you can have the minimum. If you're in an accident, it's your fault and you cause more damage than what the insurance coverage is, even if the creditor were to sue you uh, and get a judgment, they can't collect from you. Remember, you're judgment proof, your income is protected, okay? So this person writes in on a video, they said, does this apply to 50 plus, 50-year-old plus people? So what helps does our protections under the Fair Debt Collection Practices Act, and your fact that your income is protected is based on your source of income, not your age. It doesn't matter how old you are. It's still protected, okay? So Terry says, I have two debts from Synchrony. They're a beast, and even if you carry payment protection insurance, they fight you every step of the way. Is it okay to tell them to cease and desist? Yeah, they don't need to pay them. Yeah, if you're, they really can't do anything, okay? So Yin Yang asks, what if you own real property that is not exempt because you don't live on it, therefore it's not homestead property? Well, yeah, if there's a judgment against you in the county where that property is located, it could be a lien. And if it's not exempt, then the property, is a creditor going to take the property? Um, well, if you owe money on it, they'd have to pay off the loan and foreclose on it. We don't see creditors trying to foreclose on property, even if you have, or take property. Uh, Consumer judgment creditors. There might be an exception, like if it's some particular specific person, maybe a disgruntled relative or something like that, and someone wanted to pay a lot of money to try to get something. We just don't see that happening. But yeah, if you've got a piece of property that's not your homestead and they get a judgment in the county where the property is located, there can be a judgment lien on the property. That means when you go to sell it, it would have to be paid. Okay? Now, if you're able to move onto the property, then you could claim it as a homestead. Joyce says, hi, everyone. Last night I discovered I actually had $600 over the protected amount in my bank. I immediately paid 2 bills early, and that took care of that. It hasn't happened for a few years. What? You don't need to worry about it all unless you're sued and there's a judgment. And then if they were to file a writ of garnishment and the income that went into your bank account was from a protected source like a pension or Social Security, then you should be able to file what's called a challenge to garnishment or claim of exemption. The court would order that money be released. But they'd have to file the garnishment for it to be a problem if you had over twice the amount at the exact right time when there's money in there. But like you said, you pulled it out. What is your opinion of using tax-free savings accounts to save for retirement? I don't have one. I mean, I don't know enough about it to be able to tell you that. There we go. Eric, it says on my computer that by putting a child's name on the homesteaded property, that her portion of the exemption will be deducted due to not living on my property. Um, that's under state law. I don't see that being an issue. Okay. Well, you could call and talk to us. We could go over that with you. Okay. You can only see me on the nose up. That's because I'm on my laptop and I probably tilted the screen. And I was on another screen where I couldn't see the picture. Sorry about that. You're gonna have to talk to us one on that homestead one. Okay, Rico. I don't think there's gonna be an issue there for you at all. Person asks, what if you have an SBA loan? What's an SBA loan? That's Small Business Administration Loan. Okay, well, this doesn't happen very often, but okay. It is possible for certain federal debts to offset 15% of your Social Security. Now, if you owe taxes to the IRS and you're modest or lower income, you can get on currently not collectible status and not have to pay it. If you have if you owe money on a student loan, the government isn't offsetting any of your Social Security. But if you have another loan with the federal government, like an SBA or Rural Development Commission loan, maybe a VA loan, there is a possibility that the government could choose to offset 15% of your Social Security after giving you a 60-day notice of their intent to do so. And there may not be a way to stop it if that were to happen. We don't see it happening very often, but there is a way to stop it by filing a bankruptcy. So if any of you had a problem with someone taking 15% of your Social Security for a federal debt, call and talk to HELPS, and we'll talk to you about your situation. Okay? But we just don't have it crop up very often. And this person says, but your salary from a part, this was it was on one of our videos, they asked this, but your salary from a part-time job could be garnished. Well, doubtful. I'll explain why. Every state protects there's a federal law that protects $217.50 net per week in wages from garnishment in every state. Some states like Texas, South Carolina don't permit garnishment. Other states protect more than $217.50 net per week. So then they'd have to sue you, get a judgment, and then they have to know where you're working. So if you're working or you want to go back to work, I don't discourage it. Chances of that you having a problem with your wages is really minimal or zero. Okay. Person writes in, they say, I was told by my bank that if a judge has a judgment against me, they have to let them take my Social Security money. Well, you talked to someone in your bank that didn't know what they were talking about. Okay. So I'm paying so much a month for 2 years. I was told, don't worry about it, ignore it. That's not true. So I have another letter from another company that bought the account and so on. What is the truth? Okay. There's a lot of people out there giving false information, or they're leaving out, or they don't understand. Your Social Security is protected. It's been protected since 1935 when it was founded. Okay. And then in 2012, there was a rule passed that tells banks if someone gets a judgment against you and they garnish your bank account, your bank has to examine where the money came from that was deposited in your bank account. If it came from a federal source like Social Security, what they're to do is take what you received for the last 60 days, which is normally twice, 2 payments, and they're to automatically protect that for you from garnishment, even if you happen to put other monies in the account. So even if you commingled some other funds in there, as long as the balance is in there is less than twice the amount of your federal benefits, then that money, your bank is instructed to protect that money from a garnishment. Okay. And you can Google that question or search it on the internet, and you're going to find websites that are going to verify what I told you. But I've yet to talk to a bank manager that understands the rule. And I've always said that probably 999 out of 1,000 attorneys don't understand the rule. Um, why? Well, because they don't practice in this area. And they were taught in law school that if you have money that's Social Security and you commingle funds from other monies in there, that then they can take the whole amount. Now, that used to be the law, but that's not the case anymore. Um, this person writes in, they say, I just got off of Chapter 13 bankruptcy last year. During those 5 years paying, I became disabled. Last May, I lost my job and everything over this, not dreaming I was not ever going to be able to go to work again. I foolishly applied for a credit card, and of course, my card broke down, and there went the dominoes. I can't pay anything back. I've been living off of credit cards the last 10 months. I need help with summons for an unpaid debt for 2 banks with loans I'm unable to pay. Now I'm surrendering again. I'm ashamed. Talk to us. We'll go over this with you. You know, occasionally I'll talk to people that are in a Chapter 13 bankruptcy, and they don't need to be in a Chapter 13 bankruptcy. Maybe their circumstances changed and they can get out of it. Chapter 13 is voluntary. Chapter 13 is a bankruptcy where you make monthly payments over a period of 3 to 5 years. And I've talked to many seniors that don't need to be in Chapter 13. Okay? Um, okay. My computer may be dying here in a second here. Not getting any juice. So I may end helps here in a few minutes, early on Thursday. Sometimes we end early on Thursdays. Forgive me if I do. I'm from Minnesota. I need help with summons for an unpaid. Thank you for your offer of help. I'm a senior citizen living on Social Security as my only income. I recently received a court notice for a lawsuit regarding a credit card debt, which I'm no longer able to pay. Notice says that if I don't give an answer, a judgment be entered against me. Well, if you give an answer, you owe the money, you're going to get a judgment against you anyway. You don't need to worry about what should I do. You don't need to do anything if you owe the money. They can get a judgment. They can't touch your